Good evening, everybody. My name is Attorney Yasmine Moeller, and joining me tonight are my partners, Attorney Bernadine Nacua and Attorney Tercel Mercado Gephart. So on tonight's episode on Partners in Law, the Cebu Lady Lawyers Association has brought us a very special guest, Attorney Jose Hector Baronda.
Attorney Jose Baronda is the Chief of the Legal Division of the Bureau of Internal Revenue, Cebu. Good evening, sir. Welcome to the show.
Okay, good evening. Thank you for inviting me here. In behalf of the Bureau of Internal Revenue, Revenue Region Number 13, Cebu City, we are happy that we are given the opportunity to talk about the new law or the new amendment on the estate tax.
Our topic for tonight is estate tax under the train law, and we will also be touching on, just slightly touching on donors' taxes. And to highlight the benefits under the train law, we will be comparing it to the estate tax and the donors' tax of the old tax rules as well.
So let us begin with the most obvious change, which is the tax rate. So what is the tax rate under the new law?
Again, basically the purpose of this train law, the passage of this law, is to make the law simpler for the benefit of the taxpayer, considering they are our stakeholders. With regards to estate tax, the most prominent or amendment of this is the rates. Now we have a flat rate of 6% based on the net asset asset of the decedent, because previously it goes up to 20%. And with regard to that, we have also introduced an amendment on the amounts of the family home, which is before it's only 1 million, now it goes up to 10 million. And with regards to the standard deduction from 1 million also to 5 million. Another amendment to that is that we deleted the claims on deduction with regards to the medical expenses, judicial allowance, and the funeral expenses, because we believe that it is difficult on the part of the heirs to justify the amount, considering that it must be before it is allowed as deduction, it must be supported by documents.
Mm-hmm.
So, Attorney Baronda, you mentioned that under the train law, the tax rate is now a flat 6%. Under the old tax rules, it was 20%. Do you believe the old rules made it very burdensome on the heir taxpayers, which resulted in them not transferring or processing properties into their names, or not being able to properly use the inheritance that was given to them?
Yes, because basically, as I've said before, the old law is that we have so many documentations, and the rate also, I've said, it's not 20% up, but it will depend on the assets of the decedent. But as I've said, it goes up to 20%. But now, yes, because I've said the previous law is on the rates alone, it is burdensome or on the part of the heirs. Now we have only 6% based on the net asset. So on that rates alone, we can see that the new law, the train law, is more I said friendly on the part of the heirs.
So you mentioned earlier about the value of the family home being higher under the train law. You said it is now valued at 10 million. If, for example, Attorney Baronda, there is a family home that is valued at 6 million, can the heirs deduct the full 10 million?
Yes, we have to identify or classify first the kind of the classification of the family home as to whether or not it is a conjugal property or exclusive property. Because if it is a conjugal property, assuming that you have said it's only 6 million, the heirs can only deduct the family home up to 3 million, considering that it is conjugal. But assuming that it is exclusive, then the full 6 million can be claimed as deduction on the part of the heirs.
How about if the worth of the family home is at 15 million, attorney? So how do you go about deducting that?
Yes, again, we have to classify, but the law says the maximum deduction is only 10 million. So
if it's more than 10 million, you're limited to the 10
yes.
million. So attorney, how about in terms of procedure, what are the changes in the old tax law and under the new train law?
Yes, the first is the time of filing. Before, it's only 6 months. Now you have one year from the date of the death of the decedent. You can file the return within 1 year. And the rule is you have to file and pay. But you are allowed to make representation with the Bureau as to whether or not you will pay in installment or disposition of one of the properties of the decedent.
Attorney Baronda, if the taxpayer heirs decide to pay on installment, will they be free to transfer the property to their name pending the installments or only once it's fully paid?
No, as I've said, we have the rule that before we can release the property, the estate tax must first be settled. Now, the rule says that if you want in an installment, you have to indicate also on how you will pay that. If it's monthly, annually, or quarterly. So pending the
Full payment
of the installment, the property will not be released first. And you are only given to have the installment on the extended period. Meaning up to 2 years.
Oh, up to 2 years.
And you mentioned that you can select which properties you want to be released. So under the old tax rules, you had to collate the estate and pay the taxes before it can be released to the heirs.
Yes.
So how does that compare now to the new tax rules where you mentioned you can choose which properties you want to have released? Let's say Mr. X left behind 10 properties and the heirs only want to dispose of 2 and can only afford to pay the taxes on 2. So can they have those 2 properties released?
This is also the amendments introduced under the train law, because before, as I've said, you can you have to collate or to consolidate all the properties of the decedent before you can pay the state tax. But we have sometime in 2003 Revenue Regulation 2-2003, I think, it provides an installment also. The selling of properties that you can dispose any of the properties, but you will only be subjected to interest, assuming that the is allowed by the Bureau, because you have to seek the approval of the Bureau. Now, on the train law, this is now incorporated or mentioned in the law itself. Before it was only under a regulation, but now this is only now mentioned in the law that you can have an installment in cash or this disposition of to dispose any of the properties chosen by the heirs, and you can just pay that provided all the proceeds will be applied to the estate tax.
So, i-summarize lang nako, attorney. If ever an heir, kung dili sila ka-afford mo pay in cash, pwede sila maka-opt to pay nga gamito nila ang one of the properties niya, ilang ibaligya, ang proceeds ato tanan mo ilang ibaligya sa entire estate tax.
Yes. That's one of the amendments of the train law. That pwede na nimo ibaligya ang usa ka property. The heirs will choose which of the properties, then sell it with the approval of the Bureau, provided, as I've said, the proceeds will be applied to the payment of state tax.
And then to clarify po, attorney, Under the new law, pwede ba nga kanang itagi-tagi nilag bayad? For example, ang estate tax lang ani nga property ilang bayran and then ma-release na to nga property, or kinahanglan bayran jud ang tibuok nga estate tax sa tanan mga properties?
No, the property will be released. Those chosen as provided that the tax on that property has already also been paid.
So mas gaan-gaan gyud.
Yes, dako kayo na nga amendment on the part sa estate tax nato.
Murag mas practical sa
Oo.
siya.
Oh.
And then, attorney, regarding that, so kailangan ta na ay when the taxpayer applies for that installment and so kailangan na ana siya plan for the ipa-approve na niya sa BIR na.
The regulation only says that you will submit an approval from the bureau. So in the tax on the tax return, you will indicate now, assuming that you want to avail of the installment payment. You will indicate there on how you would pay the tax, if it is monthly, quarterly, or annually.
Basta 2 years.
Yes.
So you're limited with the 2 years.
So the 2 years, even if imo itagi-tagi, dapat kinanglan at the end of 2 years ang tibuok estate tax, or for that property lang, attorney?
State ang full what is this full state tax, because if you will, assuming you said that you will pay this in installment annually, then the state tax due is 1 million, then you have only paid 500,000. Then the remaining 500,000 will now be subjected to the civil penalties, which is the 25% surcharge and the interest. Recon from the time sa iyang death niya. Pero ang 500,000 na, because ang katong 500 nimo nga nabayaran na i-pre-up na to.
Okay.
What if, attorney, kay di man gyud tatanan yu ta ano, what if ang only estate sa deceased kay ang kwarta na naa sa bangko? How is this estate disposed of under the old rules, and how is it now under the train law?
Again, this is an amendment on the new law, because before, ang imong makuha before sa una is kung assuming bank deposit lang is initially you can only have 20,000 for the heirs to use that on the processing of the estate tax. Now you are allowed to withdraw the bank deposit of a decedent, provided the 6% estate tax will be deducted by the bank. Usa na siya sa atong amendment karon nga pwede na nimo makuha ang bank deposit sa decedent sa bangko. Ang imo lang dadon dito as ang iyang kaning TIN. You will apply a TIN for the estate. For the estate. So mo adto ka sa BIR, then file the form, and then para matagaan og tax identification number ang state. So, then that document you will just have it received by the bank, para ang bangko is makakuan sila nga na-notify na ang BIR ani. And for the bank also to the part sa bank in agreement nila na anay TIN ang estate.
So kaning TIN sa estate, separate ni siya sa
Heirs.
TIN pod sa deceased o
Yes.
sa heirs.
Yes.
So mahug di ay ni na ang bangko ang mo withhold sa 6%.
Yes.
So igo ra ka mo adto ipakita ang TIN sa estate, dayon i-withdraw nimo less the 6%. So ang bangko na ang mo remit ana sa BIR.
Yes. The bank will give you the 2306 form to as proof that you have already the 6% already been deducted on that amount.
Okay. Yeah.
But naana siya document. You have to attach the sworn declaration that that 6% already been deducted, and that the order, assuming that it is joint accounts, that the other joint what is this, that depositor is alive.
For example, it's a joint account. So, ang entire value of the deposit ang i-charge nato sa 6% or only how do you go about that?
No, it's only on the proportion of the interest of the decedent. Meaning, assuming na ay 100,000 and then there are two depositors, joint accounts, then only the 50% will be considered for taxation purposes, state tax.
Attorney, mag-break sa ata. So, we'll be right back after this break.
Welcome back. Earlier, before the break, we were talking about the bank deposits under the new train and how it will be treated under the new train law. Attorney Bernadine Nacua asked Attorney Baronda how to treat joint accounts. So, Attorney, can you elaborate more?
Yes, because if it is a joint account, only on the portion of the interest of the decedent will be considered for taxation purposes as state tax, because the other will be for the other depositor.
So, attorney, so for example, 1 million ang value sa deposit, bali 500,000 lang ang tax.
Will be included as estate of the decedent.
Okay. And then, attorney, what if, attorney, the kanang when you try to withdraw the deposit, can we also claim the deductions or
That's the key there, because because if you want as a katong istoryahan nga, you will just bring the TIN, the state, then you can have now withdraw the amount. No deduction is allowed. On the full 6% will be deducted. But if you want that deposit to be subjected to the deduction, you will have to file it on the regular procedure. Meaning you will have the extrajudicial settlement, file the state tax returns.
okay. So, but how about, attorney, if partial na mo i-withdraw? Pwede na siya? Then partial sad ang subject to the final tax, or you have to withdraw everything in per account?
Ang gingon sa rules is within 1 year you can withdraw that. Within 1 year lang, meaning assuming ang decedent died January 1, you have only until December 31 to avail of the bank. More than that, you have to file it regularly. Now, if you want the 6%, the partial, the rules is silent on that aspect.
Okay.
But basically, you can do that portion lang.
And then ang
Kastiganan
6% most likely kuwaon sa full amount or sa katong imong gi-withdraw lang
As
ka
I've said,
portion?
it's silent ang rules ana, but muna considering 6% ang partial lang ang partial na po tukuhaan og 6%. Ang uban i-appeal yun to dito sa
Katong regular.
But as I've said, it's
Gray area.
Gray area na siya. Wa na maiskuti sa rules kung partial ang pagkuha sa deposit.
Attorney, we have been mentioning the old tax rules and the new train law. So, when will this apply? If a person died in December 2017, what should apply? The old tax law or the new? When is the beginning?
It's the law says the train law will apply only death occurring 2018. So meaning katong namatay or died before, the old law will apply.
So they have the old rates,
Yes.
20%, and the old deductions. Okay, so when you have a loved one who dies and you are the heirs, what should be the first step that you do?
First is you have to consolidate or have the properties of the decedent. Then you go up again to the documentation, which is the extrajudicial settlement, the tax declaration of the properties, the title of the properties, and then file the returns, which is 1 year. But you are allowed to have an extension of 30 years, filing only. Filing because filing of returns is 1 year, extension of 30 days. But with regard to payment, you have up until 2 years. You can have an extension of with the approval of the Bureau that you can pay in 2 years.
Is the 2 years from the time of the death or from the time of the filing?
The rules is filing, but again we can still apply the 1 year period. Then we will count the 2 years.
The 2
Meaning you
years.
will have at least 3 years.
To raise the money. And then,
As long as the request is filed within the 1 year period. Meaning dili yun na may mga 1 year ang imong time to file sa return and to pay, ngayon kag extension after 1 year na. Dili na siya pwede. We will deny that. Unya, negligence is grounds for denial. Meaning kung maingon kay ang kadaghanan ko ng most reasons of the heirs is nakalimot man mi, we forgot to, we don't know how to file this. Wa mi knowledge ani. Well, to us that's negligence, and it is provided in the rules that negligence is a grounds for denial of the request for extension.
so in other words, attorney, if after 1 year na ka mag-file, you have to pay in full.
Yes, no more extension. No.
Oh, okay.
You can muna mo-apply nang imong ang katong civil penalties and interest.
But you can still pay in installments.
Yes.
Oh, you can still
yes,
pay in
yes.
installments.
Only that the civil and the interest will accrue.
Ang interest rates, attorney, it's still the same under the new and the old?
No, under the train law, we will have now an interest rate double what is prescribed by the central bank. Because the interest is 20%. Now, considering that the prevailing interest rate now as prescribed by the central bank is 6%, so ang amo is 12%. Double siya.
Okay, so ni-lower gyapon.
Lower gyapon ta sa interest.
Compared to the old law.
How about ang civil penalties? Is it
The
still
same na siya. The same gyapon, 25% na siya.
Okay.
Ang katong compromise is depending na siya na siya bracket. Discretion na.
Fix.
Dili, depending na sa revenue district officer.
So since we're talking about inheritance, there is this tool that some people used to use under the old law, which is called estate planning. Since certain estates are burdened by up to 20%, under the old law, some people opted during their lifetime to donate the property to their would-be heirs, where the maximum tax rate is 15%. Do you think that this is still an important thing for people to do to help avoid heavier taxes, or has it become irrelevant under the new train law?
To me, it's already irrelevant. And that is a thing of the past na siya. Because ang rates karon, sale, donation, and estate tax is the same. 6%. Only that on donation is now subject to documentary stamp tax. So, the same na sila. Pareho na sila og ang sale. Only the estate tax is not subject to the estate, which is 1.5%. So kung mayon ka mag-estate planning ka,
Muhuwat na.
murag dili na kinahanglan ba? O itigad surit gamay naman lang kay diferensya 1.5% kung mag imog yung huwaton nga sa death. Maoro man gyapon. Ug imo nang i-donate bayad lang ka og 1.5% kay assuming ang as I've said ang donation karon is subject na sa donors document.
Yeah, wala po deductions
Wala
ang
deductions.
donation.
Yes.
But is there a certain
Naay deduction siya
threshold?
gyapon katong gyapong 200
250,000 is exempt from the
Yeah.
donor's tax. Okay. So, can you give us a quick comparison of donor's tax under the old tax rules and under the new train law?
Kana before magyapon na siya ang donation is wa na siya DST dog stamps. Now we have dog stamps, and before is that if you donate properties which is considered as strangers, 30%. Ang imo lang relatives is katong we will use the brackets and the what is this, the rates provided in the code. Muna siya usas kwan nawagtang na ng strangers, meaning if you donate to stranger, to your relatives, now the same 6%.
How about katong I remember there was an exception before, attorney, na every year like you have an allowance nga tax free ang donation to I think family members. Wala na sad na siya karon.
Wala na kay 6% naman, pero
6%
ang imo lang nang ikuan nimo nga during the year naagyapon na katong 250 ra imong basihan nga ma-exempt ka, but more than that masubject na gyud ka sa.
So the 250 is an annual allowance na siya?
Yes, murag ingunahan na siya nga dili na siya kato manggod sa una is ang bracket ato dako-dako manggod sa munang imong yun na siyang murag imo bang ikuan nga mo ni siya tonya og ang sa una manggod mo tong atong the purpose of having it kanang imong i-installment ang imong donation is ang rates kay mayon kag ang total donation during the year is 100,000. So mo na siya rate assuming 10%, but if you will donate more than 100,000, mausab naman ang rates. So that's the purpose nga katong ingon imong i-staggered ang imong donation during the year. Now the same man siya, 6% ra man gyapon siya. So wa naman tay rates, wa naman tay bracket rates. So wa na dili na irrelevant na tong katong imong tagi nimo ang imong donation.
So, ang property, if it's disposed during your lifetime, either through a sale or through a donation or after your death through inheritance, the flat rate of 6%
Yes.
applies. So, this is a very big change from the old tax rules. Dili ba alkanse ang atong gobyerno?
Na ay decrease gamay ang atong ang collection, but ang the purpose is to free up all these properties nga wala ma-negotiate or wala magamit sa mga heirs because of these taxes. So mo ni atong gigamay ang atong rates para nga sayon on the part of the heirs to settle their the estate tax of their descendant.
So the train law is really for the benefit of the taxpayer. Everything is simplified, everything is streamlined, it's less burdensome. So taxpayers no longer have an excuse not to file and not to pay the taxes, because either way it would be the same rate.
Because I will use this venue to explain the train law, because the train law, this has been murag attack gini siya nga dili maayo nga law. But to me, I hope you will agree with me that this law, the wisdom is there, the purpose is there. This is for the taxpayers' benefit. What is the defect of this law is not the law itself to me, but it is the timing. Had this law been implemented before, ngawa ning atong mga factors karon, this is a very good law.
Wala ang kanang sa oil na factors.
So to me, this is a very good law. Ang defect lang is the timing.
ingon ana attorney na you said na this is actually for the benefit of the taxpayer, so and people will be encouraged to file their taxes on time, so the government wala na kay sila makollect sa na mga penalties like before.
If mabayad lang yung tanan, marimit lang ta during the year or pinakadali, mas maayo. We don't need the penalties. Ang amo is we can collect as much as collection during the year. Ang penalties is kini, this is murag kuan lang ni, penalty lang yun ni para sa kini mga taxpayer nga dugay kayo makabay, but on the part of the government we don't need these penalties as long as we can collect the that's why we have rules, we have what is this, prescription on how, when and to pay that.
So thank you, attorney. We'll go on a break, so we'll be right back after this break, so stay with us.
Welcome. Before the break, we were talking about the benefits of the train law to taxpayers and how it was really framed more to benefit the taxpayers rather than the government. So, my question now, attorney, is for those who died before the effectivity of the train law, do they have any like consolation under the train law, or is it something that what solution or what can you say?
What is their hope?
What is their hope?
I suppose it's already it's none, no, because I've said ang application sa train law is death occurring 2018, and those who died before 2018, the old rates of the old law will apply now. But we have this when Congressman Nacua, Kim Bumero conducted a public hearing on how we will go about implement an amnesty on state taxes last February, I suppose that's last February at Bay Hotel. We were asked on what our suggestion. So there is the main topic there, or the discussion is kung unsa ang rates, and then kung asa kutob ang qualified to have the amnesty. But I want this to be clear that this is still pending in Congress. Although this has already been considered since I said since February, but most likely, if assuming this will be approved, this will be implemented anytime next year. So, and the benefit of this is that under the proposal on the consolidated bill, which is 4814, this is sponsored by Defensor from Iloilo, Mero Kimbo, and Dakila Kua from Quezon, I think. The rate is 6%. So meaning wala na to tangon tong mga penalties.
Okay.
So dako kayo mura gihapog train law. So basically this would be their benefit sa train law ato ni siyang, and the purpose of this amnesty is, I've said, to free up katong mga na ma-move nga properties because of these taxes, wa ma-divide sa heirs, wa ma-use sa heirs because of these taxes. Now hopefully this bill will be approved anytime next year. The rate is 6%, and the benefit of this is that dili na makuan og administrative penalties, and kuan also criminal, because we can file cases on this for failure to pay tax, because naa naman ni siya, collectible naman ni siya. So mo na ang kining House Bill 4814 consolidated bill ni, hopefully ma-approve ni siya anytime next year.
I think a lot of people are really waiting for that.
Yes, we need also the collection, because as the President said, that we will build on the part of the BIR, we have to collect.
So kung madayon ni attorney, busy na kay mo ana next year.
Yes, we will be busy, and ang problem naman is the target is April, so this will be also during the filing, so murag magdungan, pero hopefully murag di yan dali ni madungan, but the target date is April, I think, for estate tax amnesty. But I've said I want this to be clear nga, this is still consideration.
So naay chance na madayon.
Yes, for passage, I think 70% ang chance ani nga mapas.
So attorney, kung namatay ang deceased sa 19 forgotten and then ang nabili na lang kay iyang mga apo, all that time 100 years maka-benefit sila.
Yes, ang problema lang nato ani is because maybe it will be traced out or included in the IRR on the regulation, because ang estate tax manggod once meaning sa facts nga mong gatag, assuming si A namatay og 1901, so na siya mga anak, we have to trace that, because all of this who died, who has interest on that property, is subject to estate tax. So maunay tan-awon sad, maybe usasan is ilang tan-awon kung unsaon na nato pag treat ani nga kining daghan na kay nangamatay, because this is one of, it's not only the rates, it's not only the penalties or the payment of the state tax that is holding on the air to process this inheritance, but also on how to go about this scenario nga daghan na kayo ang decedent, unsaon nimo kay ang documentation of this, kung sa ato pa is lisod kay ni kay we will file one docket for this decedent, another for this decedent.
Hopefully ma-solve na
Yes,
siya.
hopefully.
Kay ang
I think
ang kakutian na.
Useless ang willing ang heirs mo bayad, but because of this
makuha
lisod.
siya
Ilang neglect.
Lisod ang pag-comply. So usa na sa gi-consider during the public hearing on how to make it simple nga ang pag-qualify sa taxpayer sayon ba. Kay sa unam gud ang kuan sa una is daghang kaayong documentation, so munang dili kayo attractive on the part sa taxpayer nga mo avail because of this documentation. So usa na, it's not only the rate that has been traced out during the public hearing, but on how to go about nga mahimong simple ang application.
Oo, bitaw.
Historically, based on your experience, attorney, every time there's a tax amnesty, daghan ba mo avail? Or
Daghan sa nila kay kuan man sa daghan man gyud kaayo
Daghan kayong delinquent.
daghan kayong delinquent. Naami regulation on how to avail of to pay delinquent accounts, delinquency taxes, but again ang naay requirements man good. So dili mo lang, I've said it's not so attractive on the part of the kuan, but mas may na lang ni kaysa wa gyud kay option nga kung dako na gyud kay ang imong bayranan, wa na gyud kay laing mahimo. But kining revenue regulation, I think 2000 I forgot 2002 30-2002 if I'm not mistaken, naani siya option, naani siya you will only pay 40%, 10%, and kaning doubtful validity is 40%, financial incapacity 10%, but muna
Sige, kanang hypothetical scenario, what if, is it possible na because assuming na wala pa ta nag-amnesty, is it possible na because of the penalties and interests, mahurot na niya ang value sa property such that ang heirs wala na sila madawat?
yes, daghan kaayong naitabuan na daghan ang remedy sa BIR na is muna ilang we have to first is alien na mo, then sell it on public auction.
Kapilan ang mahitabo, attorney, frequent man na inyong kanang murag mahog og birahon ang yuta or dili kaayo?
Kana na siya dili na gyud kay extreme gyud kay na on our part ba nga among anaon, but we amo sa yung buhaton. nga among ibira ang property kung dili na gyud siya mobayad ba. In fact, mo na sa among option is first is we have to lien the property. So notify the assuming kung business ang iya, kung na siya ay real properties, lien the property, then notify the kuan that we have a claim on your property. Ang uban mobayad man sad kay makuha man nilang property.
Compromisable ba ng estate tax, attorney?
May naagi sa tanan kung naanag mo naanagani kay penalties naagid sad nay compromise penalty para dili tamabot sa korte mo gyud na siya kuan mo gyud na siya so mo nang naasad may rates sa compromise penalty once nga inana na interest na surcharge nasad nay compromise penalty.
And then generally, pila ang percentage ana ma-compromise kung kintahay ang heirs dili gyud sila financially capable?
Depende na siya. It will depend on the what is this the value of the property. Na siya bracket sa dito nga so dili na siya fixed.
And then at the discretion na sa BIR or no?
Not necessarily discretion but makakuan sila dito nga naay rates naay bracket gapon.
Okay.
If kuan attorney like dili mabaligya ang property, mo accept ang BIR of let's say portion of the property instead of cash, is that possible?
What do you mean?
Like for example, ang lot that is subject to estate tax is let's say 1,000 square meters and then dili nila ma-sell, pwede ba mo offer sila nga like 100 square meters na lang among i-pay for estate taxes? Is that possible? Na
Or siya ma-subdivide in a way?
Ang kuan mong sa bay is cash ba? Mura kay nana ba? Because ang amo na ami gipangbaligya is katurag yung among na foreclose. But we don't wa manggoy sa provision wa manggoy payment of property. We got the property because of failure to pay. It's not because we have the property because it is in lieu of payment in cash. No, that's not possible.
Okay. So kailangan siya i-sell.
But ang katong, di ba, revenue regulation man to before, ang katong option to sell a property, unya, ang option sa to tagi-tagi payment nga property. So, katong mga, the ones who died before train law, kanang, they can just, kanang, go to that revenue regulation.
Yes. But
para makuha
subject to
the discretion.
Subject to approval and the civil and the interest.
And civil penalties.
Kay due naman ang tax. Ang kining sa ato karon ang the new law is kung musel ka og katong sa imong kuan wala na siya civil og interest. Magkuan ka basta makuan lang nimo so ang naay katong sa kuan lang sa installment is nato siya interest ang
okay.
ang extension to pay motot siya naay interest wise or charge ang kining extension allowed you ka to pay in cash sa katong properties wag yun ni siya no civil og interest ani apply. Unya ang kuan pud sa katong extension to pay, I've said before, extension to pay and payment installment or the dispose nimong property. Sa extension to pay is naa kay wa kay surcharge but naa kay interest nga imong bayaran kay lapas naman ka. Unya besides mo put up pag the bureau may require you to put up a bond not double with the value of the property. So mo na siya diferensya sa katong installment in cash o katong kuan nga katong extension to pay mo is na kay require itong nga bond unya interest subject ka sa interest wala kay surcharge.
Attorney, kung madayon ni ang tax amnesty kay pamagyud ni sure dili man sad na siya forever.
No, yes. There's nice sunset provision ana.
So, unsa ang period na kailangan mo kanang comply ang taxpayer or the taxpayer who wants to avail of the amnesty? Like, from
Mauna.
experience.
Again, I forgot that. Usa sa na sa gi-consider sa discussion kung kano sa ang period ana. It's 2 years, 5 years, but our recommendation is para dali ba? 3 years lang tong among. I don't know if it will be considered.
The last tax amnesty, di ba katong kay Gloria na administration, how long man sad to siya ang before the sunset provision ni Kuan?
I think that's only 1 year. I
1
think.
year to siya.
Also, the 3 years, kay taas-taas sa Judeja.
Oo. Kay state man good. Katong kang Gloria is kuan man to. All internal taxes man to. VAT, income, and other taxes.
Okay. So, at least, ang katong mga dili ka dispose sa ilang property, kay lisod man sad good mo, baligya kag property, ma-discourage ang buyer kung angan sa title kay imo pang apuhan.
Yes.
So,
yes.
na sila
That's-
chance na maka-enjoy sila sa fruits sa property na ilang inherit if madayon ni
Yes,
ang tax
yes.
amnesty.
Yes.
So, maayor di ay po.
Maayo.
Mahitag madayon.
Lagi kay so many daghan kay mig na encounter na ang title kay kinsa pa 19 whatever pa.
Yeah, also pa to sa unang panahon, tag na po kabuo kang anak.
Oh, yes.
Padaghanay.
So daghan pa.
Unya kuan pag yun ni kung ining process ninyo ani because an e-car electronic certificate authorizing registration issue mo gyud sa BIR as proof nga the taxes are already been paid and remitted to the bureau. Naa pag yun we have uncovered the proliferation of fake cars.
Okay.
Fake. So meaning, wala gyud bayad ang nahitabo sa bureau. Wala gyud. So mao ni karon ang among drive karon is in fact we will be filing a case anytime next week for fake cars. So mao ni bantay ta kay naay daghang fake karon. So kung gusto gyud mo nga dili mo mahasol nga kung namoy transaction, sale of property, processing of state tax, donation involving real properties, I've said na anay e-car, kinahanglan mo hire gyud mo og ayaw ng mga fixer. Kung gusto gyud mo nga makuan is hire the lawyers. The practicing lawyers mas maayo na siya kay naay responsibility.
Oh,
Di ba?
naapoy accountability.
Oh, na-responsible accountability siya sa iyang trabaho kay muna ang kadaghanan namo sa as per investigation namo ang fake car is done by kaning mga fly by night, kaning mag-process lang ana.
So, attorney ka na, we need to wrap up. So, is there anything that you want, mga parting words para sa atong mga viewers?
Yeah. Yes, I've said December na and we need to collect for the entire 33 billion for this region alone. Hopefully you can help us. We need the funds for the expenses of the government. I've said the mandate the trust of the government is to build. So our mandate here also is to collect.
So, thank you so much, Attorney Jose Hector Baronda from the Bureau of Internal Revenue for taking the time out to explain to us this new train law, other laws as well as the donors' taxes. And to all our viewers, we hope that tonight has shed light on our new tax system, and we hope that this could be of use to you. Have a good night, and thank you.
Good night.